It's time for the midweek edition of Legal AF. And boy, do we have a lot to talk about. We're going to talk about the Trump trial. What else? It's not over. We've got jury charges. We've got Donald Trump violating his gag order, going after Matt Colangelo, who did the opening statement, used to work in the Department of Justice, and was now a special prosecutor in the Manhattan DA's office. We've got more Judge Merchan being upset with lawyers, this time Emile Bove, the lawyer for Donald Trump, about his ridiculous request to have advice of counsel or presence of counsel or some sort of defense charged to the jury. In fact, so far, from what we know from those that are privy to the charges, looks like it's going well for the prosecution in terms of the second crime issue necessary for a felony. We'll talk about that today. Then we'll pick up again with the Oversight Committee and the Judiciary Committee and their attempt at finding Merrick Garland in contempt related to Joe Biden's voluntary testimony that he gave to Robert Hur, the special counsel, and the assertion of executive privilege. We'll talk through that. And then Mar-a-Lago's back from the dead, even though that trial looks like it's definitely not going to be happening before the election. Hearings going on today as well. Unsealing of evidence and transcripts we didn't know existed involving the original search warrants and post-search warrant issues that were before Beryl Howell. Remember when we had a good judge in charge of Mar-a-Lago? Beryl Howell, then the chief judge of the D.C. Circuit Court, responsible at the time for all things grand jury. And she's the one that stripped Evan Corcoran, the lawyer for Donald Trump at the time, from stripped Donald Trump of his attorney-client privilege and made Evan Corcoran testify. Well, we got some new revelations related to that, new revelations about Walt Nauta, and a screaming match. Yes, this apparently is what happens with things involving Donald Trump, or at least Walt Nauta. A screaming match broke out in front of Judge Cannon involving Walt Nauta's lawyer, Stan Woodward, and that now infamous meeting that he held in Washington with Jay Bratt and others on the special counsel's team about whether he was extorted or not in an attempt to have Walt Nauta cut a deal with the prosecutors. We'll talk about it with my favorite former prosecutor, Karen Friedman Agnifilo. Hi, Karen.
Thanks for dinner last night. It was so fun, Popok.
You've gotten so much mileage out of this bet.
You know,
we can't stop talking about it. All right. So here it is. Popok paid off his bet. Everybody went to Nobu. I brought Sydney with us, who was one of our production assistants. We had a grand all time. It was about 6 inches from Karen's apartment. It was about literally, I think she lived over the restaurant. At least that's what it looked like. And and we had a great time.
No, it was really fun. It was fun to get together in person. Thank you so much. I appreciate it.
We learned a lot about Sydney because, really, she's one of our producers, along with Jeremy and Salty and all of that. And people have seen pictures on our Instagram and Twitter, X, about the wedding last week that we attended for Ben. And we got to spend a lot of time with Jeremy and Salton, and we posted some photos about that. Now we posted a photo about Sydney. And as we meet other producers, we will post appropriate photos. So we got that going on. You and I did a couple of rounds of Trump on trial updates to give Ben a little mini moon. He took a little mini, that's all he can do. That's all we let him do. Little mini honeymoons.
A mini honeymoon that he still dropped recordings. I couldn't believe it. We were trying to force him to stop.
He can't.
And he can't. He just can't.
It's an addiction. We'll have to do an intervention at some point, democracy intervention. But we really appreciate what Ben does. And we all do it. Listen, I've dragged my equipment, 16 pounds of my equipment around on every holiday I've ever taken since I joined the network. And you have too. And do things from all sorts of places that people don't think are podcast locations, but they become that way. Let's talk about Trump on trial. So, jury charge conference going on. To me, it looks like the prosecution's doing great. There's one in particular I want to kick off with, which is the second crime issue, because this looks like a big win for the prosecution. And I want to get your opinion about it. So just to keep everybody up to speed, Trump's violating the gag order again, and the judge will have to deal with that. And then during this charge conference, which is to get straight and work it out with the judge, what the actual jury instructions are going to be, the jury charges are going to be before they're charged. And it's really important. You said yesterday, if I recall, during our wrap, or one of them, you said, and I've mentioned it before too, it's one of the biggest grounds for reversible error around, which is to get your jury charges wrong. That's why even when the judge does it and reads them and you've approved them, everybody that's a lawyer that's involved is like reading with a finger along to make sure there isn't a mistake, a comma out of place, a word out of place. And I've been there. I'm sure you have too. When you say, "Oh, judge, you missed a word there. Got to go back. You left out don't or no or whatever." And because it's really important you get that charge right. And so they're battling it over now. And then the second crime issue is, and we've talked about this at length, but I think it deserves another pass here, is that the business record fraud at the heart of the case, which is the entry in the books and records of the Trump organization of the payment ultimately to Stormy Daniels, which got recorded instead as a payment for legal services rendered to Michael Cohen, who then used it to repay himself for having laid out the money for Donald Trump. This is so the prosecution argument goes. And then it got recorded, and then that got taken as a business deduction because that was an expense on their books and records instead of being a direct payment for hush money and election interference and all that. That's crime one. And if that's all that we were talking about, frankly, I doubt your old office would have brought crime one, misdemeanor only, in the state of New York, even though there are thousands and thousands of prosecutions of that over the life history of that statute and that provision. And they're not just picking on Trump, but it became really interesting when a second crime in furtherance of a second crime was added on, because that ratchets it up to a Class E felony in New York. And the question we always had was, and I'll just run through the checklist. This is like an FAQ, right? 1, does that second crime have to be charged? No. Does it have to be indicted? No. And what does the second charge have to be? And now the judge has solved that problem. Does the jury have to agree what the crime that's being covered up is? And do they have to have not just consensus, but unanimity about the second crime? The answer is no. So, and I want to hear from you how they're going to present this one. So 7, let's say there's 12 jurors. 7 out of the 12 jurors could think it's a cover-up related to tax fraud. And 5 could think it's a cover-up related to election interference. And he's convicted. There does not have to be unanimity. Let's start there. What's your opinion about it? And how do you think that helps or hinders the prosecution or the defense? And what do you tell? I mean, we've been following this closely. What have they been told about tax fraud and or election fraud in Kuwait in order to make that determination as a jury?
So I remember when this case was first brought, this is what the question that everyone's asked. And I'm talking to reporters, other lawyers on TV, et cetera. And everyone is asking this exact this exact question about. And I was describing it back then and still now as it reminds me of burglary. And I know I've said this before, but I want to say it again because it turns out this is exactly how the judge is doing it, exactly how I've been describing it all along, where people, really, really smart lawyers, smarter than me, actually, were saying, no, it can't be. That can't possibly be the case. And so every once in a while, I actually know something from my experience because I've been doing this a long time. And so I was very pleased to see that I didn't get that wrong because it made me concerned because there are people who thought this isn't possible. But this is exactly how it's always done. And let me explain what it is. That it's a general criminal intent. It's not, I have the intention to go out and I'm going to, the elements of a particular crime, I'm going to make sure that I meet each and every one of those elements. It's a general criminal intent, meaning I'm going to commit a crime. I'm not doing this in a way that is above board, that is legal. I'm hiding it. I am doing everything I can. It's like money laundering almost, right? But this is like you're laundering, this isn't money laundering, but it's similar to that. You're trying to make it look like something that it isn't, so that it can't be traced back to you. And the burglary example is burglary is a trespass misdemeanor, which is you enter or remain unlawfully somewhere. But it becomes a felony burglary. It's just a misdemeanor trespass plus, and the plus is the intention to commit a crime therein. And that's what I have experienced prosecuting. I've prosecuted hundreds, if not thousands, of burglaries on the course of my career. When you never specify what the crime therein is, because you don't really know half the time, right? Sometimes they get caught in the act before they've done anything. Sometimes you do know what the crime is. It's, sometimes it's sexual assault, or it's theft, or it's some other thing. And sometimes you can infer criminal intent through surrounding circumstances because you're not in the brain of the person. And so if they get caught as they walk in the door before they've done anything, you look at the surrounding circumstances to try to figure out what is it that they have the intention to do. And there's another possibility. You have a guy who's a burglar walking up and down a hall, jiggling doorknobs. He doesn't know what crime he's going to commit once he gets in. It depends on what's in there. He just knows he's going to go in there and see, and whatever it is. And if he gets caught the minute he gets steps in the door without having done anything and without having a specific intent of which crime he's going to commit, he gets charged with burglary too, because he was going to commit a crime therein. And so there is no difference between that kind of intent and this kind of intent. This is false business records, meaning you have entered or you have put some sort of entry or omission, or you have caused the entry or omission of false information in the business records of an enterprise, okay, with an unlawful intent. And that is falsification of business records. And the unlawful intent there means you didn't make a mistake, okay? So you intentionally caused false information. You didn't just get it wrong. And that's a misdemeanor crime. And what makes it a felony is if you are in furtherance of another crime, like you're doing this to either cause or aid the commission of some other crime or to conceal another crime, et cetera. And so here, that is what the jury is going to be charged in, this general criminal intent. Now, the prosecution is going to argue on summation that this other crime is going to be election violations because donating all this money that this $420,000 that they structured over 12 months to reimburse Michael Cohen for legal fees. It was a reimbursement, not legal fees. The reimbursement, but they called it legal fees. That's why it was false. The reason they structured it like that was it wasn't a reimbursement. This was in order to not have to claim this $130,000 payment to Stormy Daniels. They didn't have to claim it in to the Federal Election Commission, which they would normally have to do because it's an in-kind campaign donation. And so that's going to be, it could be federal, state, and the other is the tax crime, income tax. They made it look like income tax so that even though it wasn't income to Michael Cohen, so that he would be made whole, plus he'd get a bonus in order to get paid back. So that's how they did it. The jury charge, the judge is doing it exactly how I know this to be, how we do it in New York and how it's done in every other case. So I guess it's a win for the prosecution in the sense that the judge is following the law and giving them what it should be. But that was sort of the main decision in the jury charge conference, that the judge is going to be charging the jury next week.
Yeah, the reason I see it as, even though they're following the law, the reason I see it as a win is because if he had done the alternative, which would have been against the law, and forced there to be a unanimous decision on either election interference or tax fraud, that would have also, as you mentioned, would have basically turned the law on its head about what the general intent was. And it gives, this way, the jury has a little bit of a Chinese menu, a little bit of a column A and column B. And the jurors don't have to, and they'll have to be instructed about that. They can't just be left to their own devices. They'll have to be told, when you go back, it's okay. Because they can't be left under the impression that we've got to figure out the second crime. Because that'll just, A, it's wrong, and B, it'll waste a lot of time. They have to be told in the instruction, you don't have to reach a unanimous decision, just that there was a second crime, and you can fill in the blank about what you think that second crime was based on the evidence. I mean, it has to adhere to the evidence, and all of that. So I like that. What'd you think about Emile Beauvais' attempt once again to have some sort of advice of counsel or presence of counsel? And the argument there is, well, Donald Trump just entered into these NDAs, these non-disclosure agreements, and these arrangements with Karen McDougal and with Stormy Daniels because lawyers told him to do it, And Emile said, "Well, yeah, David Pecker testified, Your Honor. He said that David Pecker said that the arrangement with Karen McDougal was bulletproof, and that implied lawyers were involved. Judge, let us instruct the jury about that. Why don't you tell the audience about what is a advice or presence of counsel as an instruction, what it would do for the defense if they were getting it, and then of course they're not getting it."
Yeah. So an advice of counsel, first of all, what Salty's putting up, this graphic shows, the judge was not happy that Emile Beauvais raised this again. This has been litigated before. A judge says, I've litigated this before. I'm not changing my mind. But Emile Beauvais, I think, was trying to preserve the record because, look, the jury charge is one of the number one ways that a case gets reversed. So the jury charge, you have to get it right. You have to preserve things. And because that would just, what good is a conviction if it gets reversed, right? So, what the advice of counsel is, what that defense is, it's like an affirmative defense. And basically what it is it says, if you give your lawyer all the information they need to give you advice, and they give you advice, and it turns out they were wrong, and you relied on that advice in good faith, you can assert that, but you end up committing a crime incidentally. You can say, look, I relied on my lawyer for this advice. It was all done in good faith. We just got it wrong. That would be an affirmative defense. Now, what it does is, if you assert this affirmative defense, meaning you now have the burden to prove this defense by the preponderance of the evidence, which is a lower standard than beyond a reasonable doubt, which is what the prosecution has to do. What happens is it will then trigger a waiver of the attorney-client privilege between you and that lawyer, the one that you have the advice of counsel with. That lawyer can't represent you because there'll be a witness at the trial. And the prosecution then gets access to all communications, notes, et cetera, that you normally wouldn't get between the client and the attorney, because the advice of counsel defense will waive that privilege. And since they didn't assert it in time here, they didn't waive the privilege. And when they finally tried to do it and they litigated it, correct me if I'm wrong, I believe the judge found not that it just wasn't timely, but that it just wasn't appropriate here. And the judge then ruled there is no advice of counsel defense here, so you can't argue that. And I'm not going to charge the jury of that.
And what facts were developed during the trial? That this is the thing. You can't just have sort of free-floating jury instructions that don't match the facts that are before, because that's worse, right? Then you got a jury who's, talk about idle hands or a devil's plaything. Jury instructions that don't match facts are deadly. Oh, that's interesting. Let's use that. But there weren't a fact developed by a witness. So that's okay. I like Trump. Let's use that. So what am I wrong? Were there any facts? There couldn't have been, because the judge didn't allow the defense.
Correct.
So I get that, Emile Beauvais, but the judge was like, you were late, and I denied it. I denied it anyway.
Well, I think what they would say, I guess the facts they would argue, I'm trying to put myself
are already in evidence.
They'll say, look, Michael Cohen was my personal lawyer. I was relying on him to tell me how to do this. So, I suppose.
Yeah, except some of the reporting is they were focused on Pecker saying bulletproof, but maybe they were relying on Michael. This has always been a weird case for conservative traditional lawyers like you and me and Ben, because you had, some people were saying, like, in the chat the other day when you and I were doing it, like, how can you Bob Costello testify against Michael Cohen when he was his lawyer, or at least Michael Cohen thought he was his lawyer, or he thought he was his lawyer. Like, where is the privilege? So many of Trump's cases are about stripping privilege away and people testifying over it. I don't want people to come away with the impression that this is normal. I mean, I've been doing this for 32 years. I've never had the privilege stripped away from me. And I know that it is, for me, sacrosanct and ironclad. And I'm very careful about preserving the privilege that's held by the client. But here, in the cases involving Trump, Evan Corcoran Donald Trump stripped of the attorney-client privilege with Evan Corcoran, crime fraud accession. Michael Cohen, Bob Costello testifying about his client, Michael Cohen. It make people think they shouldn't go talk to lawyers confidentially because they'll end up, in some sort of criminal case.
Such a good point. It really is so abnormal and so strange. And everything that they do is so abnormal. Even being held in contempt 10 times. I've never had a situation where anyone was held in contempt in any one of my cases as a prosecutor or a defense attorney. I only know of one case that I was supervising where there was a contempt proceeding. That's it. I mean, most judges have never even done that. And yet here, 10 different times he was held in contempt in a criminal case. I mean, it's just shocking. A gag order, same thing. There aren't that many gag orders imposed in many cases. You don't have threats to witnesses or to prosecutors or to prosecutors' families or, all that kind of stuff. Same thing with asking for a recusal motion for a judge. I don't think I've ever asked for that.
Let me ask you something. I'm just thinking about this out loud. One of Donald Trump's goals has been to undermine one of our pillars of our society. Well, two, right? The government.
I think all of them. All of them.
You're right. The government, the prosecutors, the investigators, the court system, destabilize them,
yes.
devalue them, right? Leave Karen back up. So I want to ask her something. Devalue them.
It's okay. I was just shifting it. I was shifting in my seat, and Salty didn't want to.
I'm sorry. I was getting vertigo from how many times we were cutting away from Karen. Okay. Here's the question. Why won't others who aren't named Donald Trump now think it's appropriate, lawyers too, to yell at their judges, to act with a lack of decorum and respect for the system, to attack their prosecutors, bless you, and witnesses and their families? Why won't there, or do you think there will be more acting out now in courts that courts have to worry about with all the rhetoric for Donald Trump? Or do you think this is an anomalous outlier, sui generis because it's Donald Trump?
I have to say I've noticed a general lack of civility and decorum that Donald Trump has brought forth. There are people who will speak online, for example, in ways that I don't think they would ever normally speak. You saw in Congress today or yesterday, Marjorie Taylor Greene and another representative, I think her last name is Crockett, got into, just a screaming match and shouting match where their AOC had to jump in and there's like name calling and just really, really unprofessional. And same thing with the Mar-a-Lago case that we're going to talk about in a little while. There was shouting in court. I mean, it's just not the way we've been raised, if you will, just as a civil society, just the way Trump talks, the way Trump threatens people, the way Trump, calls everybody names. Everybody has some derogatory nickname and somehow it's almost like it gives permission for people to behave a certain way in all areas. It's not just in court, but I think the president, he is a leader. You set the tone. You it's like any organization, the leader sets the tone, right? Of what's acceptable, what's not acceptable, what the culture will be, et cetera. And Donald Trump has definitely, I think, really changed our society in a way that is not for the better, and it's certainly not a good thing. And I think I hope it doesn't bleed into the court system beyond him.
I agree with you. I think that social contract has been torn and thrown into tatters at our feet, and it has given license and permission to people to act inappropriately. to be at each other, to be at each our neighbors' throats, if you will. And I think it is bleeding over and crossing over into the court system. And I think the courts, if they haven't already scheduled judge camp and court personnel camp on how to handle it, it's sort of like in the airlines. You know, what the airlines have been seeing post-COVID in the amount of abuse and violence that's happening on the aircrafts, the way that had never been before COVID. They've had to retrain their personnel about how to deal with it. And it's not going, that toothpaste isn't going back into the tube. I don't think this is going back in the tube. And the federal courts are going to have a strong hand here in the future, as people are going to actually think, well, Trump did it. I mean, like you said, tone from the top. That seems okay. Well, we're going to talk about more screaming that happened in a Trump case in Mar-a-Lago today. And we'll talk about the what's going on with MAGA, who can't pass a bill, who needs Hakeem Jeffries, the minority leader, to get anything done. And when they're not doing that, they're doing things like, oh, Hunter Biden lied. I mean, I did not vote for Hunter Biden. A, I don't think he lied. And B, I did not vote for him. He's a family member at best. But anyway, that, and they're trying to hold in contempt our Attorney General, Joe Biden's Attorney General. We're going to talk about all of that and so much more. But now it's one of my favorite parts of the show. It's a word from our sponsors.
We've all had embarrassing body odor moments. Fortunately, Lumi whole body deodorant is making it so none of us ever have to worry about BO again. Unlike other deodorants, Lumi is powered by mandelic acid to control odor in a new way. Lumi delivers outrageous 72-hour odor control everywhere, from your pits to your feet, and yes, even your privates. In fact, it was patients' concern about the private part odor that originally inspired the OBGYN who invented Lumi. Fast forward 6 years later, and her game-changing whole body deodorant has now earned over 300,000 five-star reviews from people like me who love feeling confident from head to toe. You can get now a special offer because you are a Legal AF listener. New customers to Lumi get $5 off Lumi's starter pack with code LEGALAF at LumiDeodorant.com. That's LUME deodorant.com. I love Lumi because you're not limited to using it only your arms. I can use it wherever I want a little, let's just say, confidence boost. To be honest, I didn't expect to love it so much. This is a whole body deodorant. It's safe to use anywhere. And it is just amazing that it was created by a doctor, by an OBGYN, and it's clinically proven to block odor all day and control odor up to 72 hours. It's baking soda free and paraben free, and it's pH balanced for safe use below the belt. Choose from a variety of fresh, bright scents like clean tangerine, lavender, sage, or toasted coconut. Lumi's starter pack is perfect for new customers. It comes with a solid stick deodorant, cream tube deodorant, 2 free products of your choice, like a mini body wash and deodorant wipes, and free shipping. As a special offer for our listeners, new customers get $5 off the Lumi starter pack with code LEGALAF at Lumi, LUME deodorant.com. That equates to over 40% off your starter pack when you visit LumiDeodorant.com and use code LEGALAF. That's Lumi, LUME, deodorant.com, and use code LEGALAF.
I love biking and using my scooter in the summer, but the sweat can leave me feeling exhausted and depleted after a good ride. That's why I was so happy to have discovered Liquid IV. Summer requires extraordinary hydration that's built for everyday dehydrating moments. Liquid IV hydrates you with benefits like electrolytes, essential vitamins, and clinically tested nutrients. With 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients in a single stick, it's clear why Liquid IV is the #1 powdered hydration brand in America. Liquid IV is built with Live Hydroscience, the science-backed formula that's an optimized ratio of electrolytes, essential vitamins, and clinically tested nutrients to turn ordinary water into extraordinary hydration. In addition to great hydration, Liquid IV comes with incredible flavors like white peach, green grape, raspberry melon, and lemon lime. And so you know, a proprietary amino acid allulose blend is Liquid IV's innovative hydration solution with 0 sugar and 0 artificial sweeteners. Liquid IV has 8 vitamins and nutrients. It's non-GMO, vegan, gluten-free, dairy-free, soy-free, and it has sugar-free options like white peach. all of the flavors I've tried have consistently been true to the flavor. I love that I can keep some of these sticks in my car's glove box or in my bag for when I need a hydration boost. Turn your ordinary water into extraordinary hydration with Liquid IV. Get 20% off your first order of Liquid IV when you go to liquidiv.com and use code LEGALAF at checkout. That's 20% off your first order when you shop Better Hydration today using promo code LEGALAF at liquidiv.com. And we're back. All right, let's roll up our sleeves here and get back to Congress for a moment at the intersection of law and politics. We're right there. And I'll frame it and turn it over to you. So you've got Merrick Garland doing his job. He in the Office of Legal Counsel, which is the White House internal law firm for the president, if you will, gives advice to the president as president, not Joe Biden's personal lawyers, but the president as president. They have opined that it's enough that the public got the actual transcript of the 2 days of voluntary interviews that Joe Biden gave about his boxes and how they were and how many filing cabinets he owned and who made the oat tag and who wrote on the side of the boxes and all this other stuff about the minutia of his packing after he was no longer vice president and wasn't president yet. It matters. And if Trump hadn't been criminally prosecuted for doing not the same thing at Mar-a-Lago at all, I doubt this would have even taken on a life of its own. But Merrick Garland bent over backwards to appoint a special counsel. We'll leave that for another debate. That was a mistake. The main justice could have handled that just as easily. And then there's a 2-day transcript, boring transcript of the interview released. You can find it online. Robert Hur's 330-page report about his findings and his decision not to charge Joe Biden with a crime released. You could read that, but you don't need the audio of Joe Biden giving an interview. I mean, what we do for a living, Karen, me, Ben, mainly is on the papers. When we file about really important legal matters, some of the most important legal matters to that company or person that we represent, sometimes involving their liberty, it's not on the papers. It's transcripts that are read by the judge. It's not like the judge gets the transcript from a deposition or something in one of my cases and says, it'd be interesting. Can you send me the video? Hey, they don't need that. And so the only reason, of course, that MAGA wants the audio is because Trump wants the audio in order for the RNC and the rest to slice and dice it into some sort of, deep fake commercial for Donald Trump in which Joe Biden, stumbled over what yogurt flavor he had earlier in the morning, and they make a big deal out of it. They have the transcript, and that's all they really need. And so the White House counsel's office and Merrick Garland ultimately recommended to the President of the United States that he assert executive privilege because it would put a chilling effect on future investigations, high-profile investigations, if all this stuff came out to the other branch of government, in this case, Congress. And remember, Congress doesn't just get to do whatever investigation it wants to do. It has to be tied to a legislative function or a fact-finding function around something that's relevant to Congress's powers. So it can't be impeachment of Joe Biden because this set of acts happened after he was stopped being vice president and he wasn't president. So it's not that. And so they don't like the fact that Merrick Garland isn't going to turn it over, and they want to find him in contempt. What do you think about the Joe Biden's assertion of executive privilege here? Was it right? Was it wrong? And what do you think MAGA does about it in this performative thing we're watching, where they're just trying to, take a pound of flesh out of Merrick Garland?
Yeah, I mean, it's hard to say what's right and what's wrong when the decision to appoint a special counsel in the first place was wrong. Joe Biden didn't have to sit for this interview. He didn't have to agree to be recorded. I mean, so many things. Joe Biden is he's such a decent person. And he's such a just nice guy who is desperately trying to play by the rules, but the rules don't apply anymore. The decorum, the norms, what we were just talking about doesn't apply anymore. What MAGA does, they don't act the way anyone can resemble what normal was or what is civil was. And the reason I say that is because in the olden days, a good politician like Joe Biden and Merrick Garland would say, you know what, I think I'm going to appoint someone who's a Republican to investigate me because I'm so confident that I didn't do anything wrong. I have nothing to hide. And it shouldn't matter if you're a Democrat or a Republican, if you're a legitimate investigator, you will find that. And the reason I'm going to appoint a Republican is that so nobody can call into question the integrity of the investigation, that even they will see that this is the right thing. And they did the same thing with Hunter Biden, right? They left in a Republican special counsel to investigate Hunter Biden for the exact same reason. Hoping that it would somehow give credence to the findings. Well, when I say they don't, that they're playing by a different set of rules, they're playing by old set of rules where people were human beings who got along with one another, and we cared about things like the truth, and we cared about things like justice, and we cared about things like following the facts wherever they lead without fear or favor. MAGA doesn't do that. And so you don't inoculate your decision making because you appointed someone who's on their side. It just doesn't work. And so that was a mistake to begin with, right? But Joe Biden's a decent guy. He does that. He says, I'll cooperate. I'll sit for an investigation. I'll even allow it to be recorded. And I think that was a mistake, right? Because what happens? Her turns around and writes this ridiculous report that added all sorts of information that was unnecessary for the report and was just really just taking unnecessary pot shots at Biden, and taking into consideration things that I don't think is appropriate to take into consideration, like jury nullification because he's an old guy. I mean, come on, if that's not a total, if that's not just a total by the MAGA playbook to give them something to work with, I don't know what is. But so then you get to they release these transcripts. So therefore, they have everything they need to conduct a hearing. That's what if you ever file an appeal in court, what do they look at? They look at transcripts. The appellate courts. What does the Supreme Court look at? They look at transcripts from the proceedings below. What are transcripts? They're the typed, written documentary transcription of whatever was said. There's no video that anyone watches. There's no audio that anyone listens to. You review the transcripts. And that's why you do things during trials like let the record reflect, that the witness is raising their hands up in the air and waving them at the defendant's table, or, whatever because otherwise you won't see any of that when you're reading the record, when you're reading the appellate record. And so you have to make a record of everything. And so they released that. So if they were really looking to provide oversight or doing something legitimate, they could look at that transcription and have what they need. But that's not the way it is. What they want is they want to be able to get the recording and take little pieces of it and put them into campaign ads against Joe Biden, take them out of context, et cetera. And that's just inappropriate, and that's not right, and that's not what this is for. And so I think the Office of Legal Counsel, I think the most important thing you said is what the OLC is. They don't represent the president; they represent the presidency in a way, right? They don't represent Joe Biden as Joe Biden. They represent the office of the president of the United States, and their job is to protect and preserve that no matter who is sitting there, right? The Office of Legal Counsel, there are people who are there from administration to administration. It's a nonpartisan office that is there to work for the presidency. So I just think that it's just really outrageous that they want this, and I think it's just all political theater. And I do think the Office of Legal Counsel was 100% right in counseling Joe Biden and the presidency and Merrick Garland in this way.
Yeah, the end result is going to be nothing, because Congress can't go out to court and prosecute Merrick Garland for contempt. They can make a finding, and then they can ask nicely the Department of Justice, which is just recommended at the highest level, that executive privilege be asserted, which it was appropriately by a president in office about things that it's proper to assert executive privilege about, especially things that preserve the co-equal status of the three branches of government: executive branch, judiciary, and the legislative. And you can't have the legislative, sort of peering in to the prosecutor's underlying mental impressions and paperwork, or in this case, an audio version of something that's already been released in hard copy transcript. It's just unnecessary. And if that were to happen, nobody would want to give voluntary cooperation, because then what's going to happen. Same thing happened with the video tapes of all the security cameras for Jan 6th. They get sent to the MAGA's favorite right-wing commentator or news organization, and it shows up in some special. and we can't trust them to be honorable with the use of it. They'll do a whole best of Joe Biden stuttering, because he's a lifelong stutterer, and run it as a commercial and a campaign ad. And it's just unsavory. It's inappropriate. And he did the right thing. And so the Department of Justice is never going to take up that recommendation. Then they're never going to bring, based on the proper assertion of executive privilege, they can't bring a prosecution against Merrick Garland, even if they wanted to. I mean, their own internal DOJ manual says that. And their own Office of White House Counsel says that. There's no criminal intent, especially when he's been told by the President of the United States, I am asserting executive privilege. You are not to release that. That's sort of the end of it. You don't litigate over that issue in a court of law. But, it doesn't matter to MAGA. None of this matters. They're not, just to be clear, they're not doing it because they think there's a legitimate basis to find Merrick Garland in contempt, or Secretary Mayorkas impeach him for what's going on down at the border that's been brewing for the last 20 years, or impeaching Joe Biden, or because of Hunter Biden.
Or why aren't they holding hearings on Sam Alito's false flag upside down? Why aren't they holding hearings on real issues? Or why? Yeah, go ahead.
Because they're too busy writing letters to Fani Willis and sticking their big fat noses into, talking about law and politics, sticking their big fat noses where it doesn't belong, which is in state level prosecutions of people that happen to have one time held elected office. Why does Jim Jordan or Jim or Jim Comer, why do they get to even have a dialogue why do they even have to have a dialogue with prosecutors about them doing their job under their state penal codes? It's just, but they get mileage out of it. They get votes. They get holds their party together. They get money. We know why. Trump tells them to do it. That's why we're watching it. So anyway, we're going to talk about more screaming, more unsavory, more unprofessional down at Mar-a-Lago with an update there. But first, let's have another word from our sponsors.
Many people are surprised to find out that I'm 57, almost 58, and that I'm a grandmother. That's why I love this product, One Skin. This is something I use on my face every single day, and it makes me look younger. I think that's why people think that I'm younger than I actually am. It's super easy to use. You just use it with any of your other skincare products in your skincare routine. And if you're like me, especially this time of year, you always wear sunscreen on your face. And this product, One Skin, has a sunscreen that I use every single day to help protect my skin, but it also helps nourish my skin and repair my skin with this OS1 that they have, this specially designed ingredient. So I love it. It also, you use it on your neck area, and it gives you lots of protection, 3 different types, in fact, from their non-nano zinc oxide, their potent antioxidants, and their OS1 peptide, which is the ultimate defense against UV exposure, collagen loss, and cellular aging. So I absolutely love I love OneSkin. And what really makes the OS1 incredible is it's not just a sunscreen, but it really is scientifically proved to switch off the aging cells that cause lines, wrinkles, and thinning skin. They also have a full body product with sunscreen that you can use. And so it can help also the rest of your body, not just your face. So I've been using this regimen for a while now, screen, and I'm really hooked. Don't just take my word for it. It has over 8,000 five-star reviews. It was recently recognized by Fast Company as one of the most innovative brands of 2022, and my mother noticed. And if my mother notices, it must be true. She's actually said to me, "What are you doing to your skin? It looks so good." So for a limited time, you'll get an exclusive 15% off your first OneSkin purchase using the code LEGALAF when you check out at oneskin.co. Try OneSkin today to get this trifecta of protection for nourished, glowing skin. That's oneskin.co, and put LEGALAF in as a promo code when you check out. It's the world's first skin longevity company. So by focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. Get started today with 15% off using code LEGALAF at oneskin.co. That's 15% off oneskin.co with code LEGALAF. After your purchase, they ask you where you heard about this. Please support this show and tell them we sent you.
Landfill space is filling up fast. 35 million tons of food waste goes into landfills each year. But Lomi provides a solution to this climate catastrophe. Food waste isn't actually waste. It's a valuable resource for our planet. Lomi helps to transform food scraps into nutrient-rich food for your garden, houseplants, or yard. Instead of dealing with stinky, gross, buggy compost bins, you can simply transform your waste at the push of a button. Lomi transforms your home into a climate solution, lowering your carbon footprint and helping keep the planet a little greener and your home a little cleaner. And now, Lomi's new app lets me track my environmental impact, earn points for every cycle, and redeem for freebies from Lomi and other great brands. I learned that food waste makes up a huge portion of our personal carbon footprint. By reducing the amount of food I send to a landfill, I'm helping do my part for the planet. Don't miss out on your chance to get the best gift for yourself and Mother Earth. Order your Lomi today. Head to lomi.com/legalaf and use the promo code LEGALAF to get $50 off your Lomi. That's $50 off when you head to lomi.com/legalaf and use promo code LEGALAF at checkout. Thank you, Lomi, for sponsoring this episode. All right, we're back. Rapidly making progress. This is a very efficient episode. Let's talk about what have you heard so far about Mar-a-Lago? Why don't you lead off on it?
Yeah, look, there's just a hearing going on. I think 2 hearings going on today, and that is turned into a screaming match, apparently a shouting match between prosecutor and Walt Nauta's attorney, Stan Woodward. And they had a hearing in Fort Pierce, Florida today, which is for Walt Nauta. And the argument was basically in going over a disagreement that they've had, this prosecutor and the prosecutor's name is Jay Bratt, and Nauta's defense attorney is Stanley Woodward. And there was a meeting in August of 2022 between the 2 lawyers, and Stan Woodward has claimed in court that that Bratt tried to pressure him into convincing Walt Nauta to cooperate against Trump by threatening him, and basically by threatening him, saying, "Oh, you won't get a judgeship as a result." And then Walt Nauta, and this is what the hearing was supposed to be about, was he claims he was criminally charged as retaliation for not cooperating against Donald Trump. And, Woodward said, look, he was recommended, he claims, for a judgeship, and that there was a folder about him on the table. And he basically said that Bratt referenced that judgeship recommendation during this meeting. And he basically said there was an implication that, he had to convince Walt Nauta to cooperate with the investigation. Otherwise, there would be consequences to his judgeship. That's what he's basically saying. There was a defense attorney, David Harbach today, a prosecutor, David Harbach today, who accused Woodward of engaging in, gamesmanship. He called it a garbage argument about the meeting. He said Mr. Woodward's story of what happened is fantasy. And I guess the prosecutor was banging his hand on the lectern in front of him, saying it didn't happen. I don't know. It doesn't feel like any court that I know that this is going on in. But, this hearing happened despite the fact that Judge Cannon has indefinitely delayed this trial. She hasn't even set a trial date, which is ridiculous. And that's in addition to so much more that is coming out about this case. Now, at this hearing, apparently it just became this screaming match where the judge had to get involved and tell everyone to calm down, and they were going back and forth, and then Woodward said, I'll testify under oath about what happened at the meeting. I mean, it's about the lawyers. It's not about Nauta and the cooperation. And it's interesting because some people think that the selective prosecution, which is what the hearing was supposed to be about, they think that because Nauta is so low down the totem pole and they gave him a chance to cooperate before prosecution, that this was somehow retaliation for that. But it's such a common tactic for prosecutors to basically reach out to people who they would normally cooperate. It's like, look, I've investigated a crime. I've identified these 10 people who committed the crime, and I'm going to reach out to some of them if I think that they are people I would be willing to make a deal with and let them flip and make them part of my case instead of a defendant, especially if they're much lower level on the totem pole, in all of this. I mean, look, no one thinks that Walt Nauta would have stolen or moved or possessed or had anything to do with classified documents but for Donald Trump. He's just Donald Trump's pawn in this. And so it makes sense why they would want to cooperate him. And it also makes sense why they would reach out before indictment and give him that opportunity, because, there's a big difference between being convicted versus cooperation. So it's not selective prosecution. Any other judge would find that. I don't know what Judge Cannon's going to do, but that's I think that was one of the big things that happened at the hearing today.
Yeah, I think you covered that well. We got some new sort of late breaking news. The Sam Alito flying inappropriate flags over houses has a new example. Sam Alito, who's a fellow New Jersey person like me, used to be on the New Jersey Supreme Court, apparently, like many people in New Jersey, summers in Long Beach Island, New Jersey, where some of my friends actually have a house. We call it LBI for those that don't know the area. And apparently they found a flag that we just put up there that is what's called an Appeal to Heaven flag there, also known as the Pine Tree flag, that was carried by rioters at the Capitol on Jan 6th. It's a symbol of, there's one there. There's a symbol of support for Donald Trump and Stop the Steal. It also encourages more Christian values in government. Just the type of flag you want flying by a United States Supreme Court justice as he's hearing matters about Jan 6th and the separation of church and state. Look, we all know that Sam Alito is in favor of Christian values being injected to everything. We all know where his position is. He's been quite public in his rulings about what he believes is the proper role of religion in politics and in our government. He talks about it all the time when he's off for summer vacation at various Catholic universities, including 2 summers ago for Notre Dame, bragging about the Dobbs decision in which he wrote away a woman's right to choose after 50 years of constitutional protection. And he did it just recently at a commencement address that he gave. It's commencement season, in which he talked about religion under attack in America and free speech under attack in America. It's almost like he knew the New York Times and other places were going to find the photos of him flying a flag. Now, you want to fly your flag in your opinions where we can do something? Great. But to show the world, could you imagine riding by? You and I are going to argue something in front of the Supreme Court about religion or Jan 6th. And we ride by, Google Maps, Google Earth, whatever, tells us that's Sam Alito's house. And we see a Stop the Steal Christian flag flying from his house. What does that do to us in terms of believing that justice is blind, or that we're going to get a fair shake in front of this judge, that he hasn't prejudged, so to speak, the issues?
And they called Judge Merchan conflicted because he donated $35 to a Democratic cause, and because his daughter works for a Democratic political consulting firm. And can you imagine if Judge Merchan was
flew a flag?
Yeah, I mean, no, flew something that can you imagine? Like, it's just shocking that Trump will say things about the most conflicted judge ever.
How about do it that way? Judge Merchan is flying, or Judge Chutkin down in D.C. You ride by her house on a tour. You look over, and there is a dark Brandon or Midas touch flag flying from their flagpole. First of all, the Democrats wouldn't blame their spouse. They would say, my wife did it.
What a chicken shit excuse. Like, own up to it, Oh,
who did it there? Who did it in the summer house? The wife again?
Yeah,
she's the keeper of the flags. I mean, if this doesn't, and shout out to whoever, rode by the house in LBI and found that flag at the right time. But what is Roberts? I mean, I know all the organizations and ones that we support are going to file ethics charges and ethics complaints and lawsuits or whatever they can. Maybe if we ever can get an appropriate Congress, we could start an impeachment proceeding. It won't be now; it'll have to be in November, but that's okay. We're patient. We'll wait. But that's what could happen right now. You can make a judicial complaint, but Chief Justice Roberts has to do something about it. The fact that he just does nothing about the ethical compromises and the ethical conflicts of his own court, Clarence Thomas and the money and the RV and the vacations, Justice Roberts with the wife making money from all of the legal placements in law firms for law firms that appear regularly in front of the court, Gorsuch selling his summer home or some piece of property to a lawyer who regularly appears in front of the United States Supreme Court. It's just, I mean, if you're a Supreme Court follower like we are, and you've read all the books from the Brethren to all the more recent ones, we've had like Abe Fortas step down because he took a $40,000 fee for doing some legal work while he was a Supreme Court justice, and he was shown the door. That seems very, very mild compared to what we're watching now with Sam Alito. What do you think's going to happen? What do you think should happen? And then we'll figure out if it's going to happen.
Oy, what do I think's going to happen? Nothing.
Well, no, what should happen?
I mean, he should recuse himself, from any Jan 6. I mean, look, the court is hearing presidential immunity, right? They are hearing that question. They are about January 6th. They're also hearing, the court is also right now hearing about the statute 1512, about whether that can apply to the Jan 6 and Donald Trump, whether that statute can apply as a criminal statute and eviscerate half the indictment against Donald Trump. I mean, he has to recuse himself. He is literally actively showing that he believes, look, do Supreme Court justices have beliefs? Do all justices have beliefs? Yes, they're human beings, but he's actively showing that by putting flags outside. I mean, it's almost like you might as well just put the middle finger up, to anyone who comes before him in court, because that's what you're doing. And, it's in addition to, I mean, the appearance of impropriety is,
right.
is
the thumb on the scale. I mean, I understand it's the scales of justice. They're supposed to be blind, but you're not supposed to come in seeing a big fat thumb on the scale against you from the moment you start advocating your position. I mean,
and you know what? He's not political. So even they have to apply the law,
Yeah.
to the facts. They can't even put their own opinion in. They're not legislators. And so it's just inappropriate.
How about this? Well, and this just shows you how wrong it is, because even if you say it out loud, it's just terrible. Suppose you and I were an advocate before the United States Supreme Court. And on the way over, or now, of course, we learn about the flag. And well, it doesn't matter what we're arguing, but let's say we argue something that goes to Christian values or religion in politics or whatever, or Jan 6th. What if I or you as an advocate during our 20 minutes, we started with, well, I'm prepared to answer any questions from the bench. And of course, I'm prepared to present my argument, my roadmap for my argument. But I have a question for the bench, in particular, Justice Alito. On the way over, Justice Alito, I saw a flag flying over your house, not one house, but two houses, which seemed to indicate that you were aligned with the Stop the Steal movement and or religion in the government. And I'd like to ask if you are going to be able to be fair and independent and impartial during my oral argument. And that's a question for the bench. Somebody's going to have the balls to ask that if he's not going to recuse himself, because it's a missed opportunity. So what does he say? It's inappropriate. It's inappropriate. What's he going to say? Find him in contempt? It's inappropriate to ask me that. Or he just stares at him, just glares at him like Bob Costello, stares him down. What's he going to do? The fact that we're even talking about this and thinking about what could happen next it just shows you how terrible it is. I've never had a situation, I've always suspected that there's judges that are on one side or the other on politics. But frankly, you don't really, you know who appointed them. But federal and state judges, it doesn't seep in the way it does at the United States Supreme Court level. Who's supposed to be apolitical and above it all? They keep saying that in all their speeches, all their commencement speeches, all their stupid, whiny interviews, and yet he's literally flying the flag of one side of the case while he's presiding over it. It's just mind-boggling.
It's mind-boggling.
Yeah. So, I think it's got to be a combination of pressure campaign by the Senate Judiciary Committee led by Sheldon Whitehouse and the minority of the Democrats on the version of it on the House going after it. Maybe we start impeachment proceedings over it. At least draw up an article of impeachment and have it be voted upon. I mean, maybe that's what, like you said, take a page out of their book. Maybe that's what needs to happen. Maybe they need to draw up that. Marjorie Taylor Greene's constantly drawing up articles of impeachment or no confidence votes on the speaker. Let's us do something about Alito. Like, enough is enough. How many times does the American people have to be a piñata and be beaten by these Supreme Court justices? And we just sit there and we just don't do anything. I mean, it's very interesting.
We don't do anything. And when we do, we appoint special counsel from their side, hoping that somehow it's going to have,
right.
Like.
To your point, Judge Merchan, I did a hot take on this last week. Judge Merchan got a cautionary letter. It's the lowest level of things that can happen, along with about 3,000 other judges, because he donated at that $35 level to a particular political party. Now, I assume his daughter, who's a political fundraiser, encouraged him to do something on Act Blue, which is where he donated, and $20 went to Biden out of the 35. He got a cautionary letter for that. Then then Alito should be drawn and quartered for what he's doing. I don't want to hear when I wake up in the morning some bullshit email that Alito sends to the New York Times again, like he did last week, where he comes up with some ridiculous justification or excuse for the flag on his LBI vacation home. There is no excuse for it. There's no justification for it. I'm sorry that you and I, Ben and Legal AF, we want our justices to at least have the appearance of impartiality, right? The justice is blind. That's why she's wearing a blindfold. It's not supposed to be a big fat finger of Sam Alito on the scales of justice, for one side or the other. It's just, and what if the left side of the Supreme Court had done something similar? Sotomayor, Kagan, Ketanji Brown. Suppose Ketanji Brown Jackson or any of them flew a Black Lives Matter flag or a gay pride flag or anything, I would think that's equally inappropriate for a United States Supreme Court justice, not for other people, because they don't have First Amendment rights. I know that Alito likes to talk about it. Oh, the First Amendment is under attack. Right. You don't, I'm sorry. You either have First Amendment rights or you can be a United States Supreme Court justice. You don't get to have both. That's as far as that's my opinion. What do you think, Darren?
It's interesting because there's certain things that to me aren't political,
Mm-hmm.
like gay rights, like that's not, to me, that's just not political. That's, human, or I don't know. Like, it's funny that you would say that. I'm not sure. I think, I don't know. I think I do think it's important that they remain neutral. I do think, when I was a prosecutor, I was never allowed to engage in anything political ever. And so I made it pretty clear. I never did. I never donated money. I never, even though I could have donated some money, but I didn't do anything political. I just thought it was important to stay neutral as a prosecutor. I didn't get involved in any campaigns and that kind of thing. But gay marriage, gay rights, that's just something I wouldn't have thought is political, but I guess it is. Just interesting. It's an interesting question of what they should or could do. I do think if you do, though, I do think you might have to recuse yourself on certain issues. If you do, if like, let's say you, were anti-NRA. But again, I don't think they should be allowed. I don't think they can do that. I think you're right. I think as a Supreme Court justice, you have to be really careful because it's important. The appearance of impropriety is just as important. You got to be neutral.
And look, they browbeated Ketanji Brown Jackson into agreeing during her nomination confirmation process, and Ted Cruz led it, that she would not preside over and would recuse herself from the affirmative action case because Harvard, where she went, was one of, they all went to Harvard, by the way, many of them, well, and she would and she wouldn't preside over it. She agreed, and she didn't. And where, it's deafening, the silence by the MAGA and the right and even the country club Republicans about what is going on with the right wing of the United States Supreme Court. We're like, I'm saddened by it as a patriot and as a lawyer that has always admired my profession. But, that's that. That's the intersection of law and politics for you folks. We've reached the end of an episode of the show we like to call Legal AF, and now you know why. It's every Wednesday and Saturday right here. I do it on Wednesdays with Karen Friedman, Agnifilo, Saturdays with Ben Meiselas, and then we do hot takes, the leaders of Legal AF, I don't know, about every hour at the intersection of law and politics. If you're interested in the law side of law and politics, we've got a Patreon, patreon.com/ there we are, /Legal AF. And I got one up right now on like a tutorial, a Popok talk on the difference between opening statements and closing arguments or summation. So we really drilled down in a way that we try to do here to be as part of the education process and to simplify things to make sense without dumbing them down. But we do more of that over there. It's for the non-lawyer, but we have a lot of lawyers that are interested. We got over 3,000 Patreons who support the show, patreon.com/Legal AF. Other ways to support us, just as a reminder, we have an audio version, of course, of this podcast, the classic podcast, and that drops in a few hours. Listen to that, watch us, thumbs up, comments, all that kind of feeds into that algorithmic computer and tells the world or the people that matter in this process, the ranking people, that we matter. And so that's important, keeps us on the air. We're building this network with our bare hands with your help, and we really appreciate that because we don't have outside investors. We have, you want to talk about flying a flag? You can fly the flag of Midas Touch and Legal AF with the Legal AF store here, Midas Touch store, store.midastouch.com. Now world famous because of the Michael Cohen and the trial. We made the history books. There you go. And you can find all of the merchandise you're looking for there. And then sort of word of mouth. We do what we refer to only half tongue in cheek as Legal AF After Dark because we show them late at night as a way to kind of pick up I almost said insomniacs, not insomniacs, because we have a worldwide audience. Just pick up people who didn't happen to see this particular show. We were kidding around yesterday and texting back and forth. There's a whole group out there that support Legal AF that only know about live and live versions of things on the Midas Touch YouTube channel. And then there's a group that has no idea what we're talking about live, and they only get the hot takes and things like that. And so there's something for everybody here, right? It's a smorgasbord of things that you're interested in. And so we do these Legal AF After Darks. There are these 10-minute segments of the things that we just did during the show. We post them. You'll see me do them. Then if they're for you if you missed the show or if you didn't have time for the full hour and 20 minutes, but take that clip, send it off to people in your life and say, hey, you know that show I really like, Legal AF? Here's an example of it. And maybe they'll join our audience as well. So it's a way to sort of be part of our ad hoc marketing department. So that's it, Karen. You're going to do the last lead off for the trial. No trial today, no trial the rest of the week. Picks back up on Tuesday with what? Charge conference?
I think they had the charge conference already.
Okay.
So I think the judge will let them know what the charges will be and then summations.
On Tuesday?
On Tuesday, yeah. Summations
and deliberation
are on
Wednesday morning or something like that.
Something like that, yeah.
So we're going to have a verdict for the trial that people said would never happen. Donald Trump would never see the inside of a criminal courtroom. Wrong. That he would never be indicted by a jury, grand jury. Wrong. Okay? Now we're going to see what happens. Now the rubber meets the road with 12 members of this jury, 7 men, 5 women, as they go back and deliberate to try to find unanimity about the charges in front of them. And we'll have a verdict by, hopefully, or as you've said yesterday when we were talking, a hung jury, which we don't want, knock on wood, sometime next week. I mean, it could roll. It could keep rolling. We'll see. I'm not making any more bets. I got to pay off this one first. I got to take out a home equity loan like Cohen. So anyway, we've reached the end of Legal AF. Shout out to the Midas Mighty and the Legal AFers.